That's better. Pierre, good morning. Good morning, everyone. Can you now hear me?
Good morning, Vaughan. I can hear you. I could always hear you, but you had difficulty hearing me. Can you hear me now?
Yeah. Yes, I can, Pierre. I think I'm pushing the wrong buttons again. Nothing unusual, eh? Especially this time on a Saturday morning. Pierre, welcome and thank you very much for agreeing to do a presentation today. I know you're an old hand at this, and I thought I'd just quickly give a quick introduction to everybody. Pierre is a seasoned campaigner, adjudicator, arbitrator, and long-time practitioner. I think Pierre is also the current chairman of the Arbitrators Association. So I think we're all very privileged to listen to Pierre today, talking about probably what is one of the most important aspects for a successful adjudication, and that is the penning of an enforceable award. It's something which improves over time and with practice. And as I say, something that is absolutely critical to the adjudication process. We're also seeing, yesterday I read there was there's a matter before the Supreme Court between Farmerton and Eskom involving enforceability of an adjudicator's award, which makes for very interesting reading, and I'll make it available to everybody on Monday. But one of the issues on the appeal was the question of jurisdiction and the way it was dealt with, how the adjudicator in that matter understood the disputes and recorded what those disputes were. So the adjudication award is probably the most important element in the adjudication process. And as I say, I'm sure we're all going to learn a lot from Pierre today. Pierre, thank you once again. Delegates, welcome again to the second day of our two-day program. This is, I hope, one of many that we're going to be doing over the next year. And Boitumelo, thank you very much for organizing. And everyone enjoy the next couple of hours. As I say, we're in a privileged space to have Pierre talking to us this morning. And again, if you do feel free, if you need to post questions, if you want to address these outside of this forum, please feel free to email myself or Boitumelo and we'll deal with those. And Pierre, thank you once again.
Vaughan, thank you very much for having me. I'm very pleased that you've invited me, and it's always nice to engage with practitioners as we grapple with issues concerning adjudication. I'm very interested to see that Farmerton judgment, because I read the judgment in the court a quo, also read counsel's heads of argument, and I look forward to receiving the judgment from you on Monday.
Perfect. I'll send it through to you, Pierre. Thank you once again.
And thank you for everyone attending. I hope that you will find the talk useful and informative. It will be a very practical talk. I had notes distributed in advance of the talk and also a case study of an award, which I hope that you've all received. But before I deal with my notes and thereafter with a case study, I would just like to state a few general things. And forgive me for stating the obvious, but I think it is always important to focus oneself on what it is that you are dealing with before you start to discuss the intricacies and the details, in this case, of writing a determination in an adjudication. An adjudicator operates as a tribunal created by contract, and express contractual terms govern the procedure that the adjudicator must follow. And these proceedings culminate in the adjudicator's decision or determination, as we usually refer to it. The unique nature of adjudication has an impact on how the adjudicator should approach his or her task and go about writing the determination. It is an expeditious process, and it occurs in the main during the course of a construction project. The parties to the project continue to discharge their duties and obligations towards completion of the project. And this is not interrupted by the adjudication process, or it's at least not supposed to be interrupted by the adjudication process. Now, having said that, we can immediately see that adjudication is a unique procedure. I think it is a very important procedure, and in my personal experience, a very successful procedure. I don't know if the attendees or most of you will agree with me, but I think the majority of adjudicators' decisions are never taken on arbitration or disputed in court. Having said that, it must be understood that there are material differences between arbitration on the one hand and adjudication on the other hand. And these differences, I think, make an adjudicator's task more onerous. You know, normally in an arbitration, the arbitrator will have the luxury of pleadings. The pleadings will define the issues. There will be discovery of documents. The arbitrator will hear evidence. He will listen to legal argument. And this normally happens within a convenient, agreed time frame. And ultimately, the issues before the arbitrator are defined. The necessary evidence is before the arbitrator, and he or she can consider the legal arguments and then embark on the task of writing the award. But running up to writing the award, the arbitrator's task is mainly to manage the process. Very rarely is the arbitrator under severe time constraints to deliver the award. However, an adjudicator, I think, should from the outset of the adjudication process have his or her determination in mind. And that is so because time is always of the essence. All the major construction contracts contain strict time limits for the filing of papers and ultimately the publication of the determination. The adjudicator is always, unless the parties agree otherwise, under severe time constraints. The adjudicator may be called upon to decide one or more complex disputes, sometimes involving enormous amounts of money, and he may have to digest voluminous papers in a short space of time. The time frame remains the same, irrespective of whether it's a 100,000 Rand dispute involving 500 pages of documents, or whether it's a 100 million Rand dispute involving 20,000 pages. So if the adjudicator doesn't, from the very beginning, focus on the ultimate goal of publishing his or her determination, the adjudicator will inevitably run the risk of producing an inadequate determination, or worse still, run the risk of delivering the determination out of time. Now, the specific contract out of which the dispute arises is vitally important, and particularly the dispute resolution process that governs the adjudication. The adjudicator should familiarize himself or herself of this at the earliest opportunity, because the rules applicable under the different construction contracts have some important differences. It is an adjudication process under, for instance, a GCC contract is not the same as under a JBCC contract. And adjudicators should be alive of that fact, and they should familiarize themselves with the particular rules applicable in that particular case. Now, first, the adjudicator will receive the claimant submission. It should contain all the relevant facts and legal contentions and must be accompanied by the supporting documents. And at this stage, it is important for the adjudicator to familiarize himself or herself with the relief sought by the claimant and whether a case has been made out for the relief sought. If it appears that the case is lacking in some respects, the adjudicator may ask for more information or wait for the respondent's or wait until the respondent's submission is received and may then ask for further information. But I must just at this stage stress that requests for further information should not be used as a tool to prop up a defective claim or a defective defense. The purpose of requests for information is to assist the adjudicator in arriving at the decision. And the adjudicator must remain neutral. So that is why I said requests for information mustn't be used to prop up defective cases. Now, once the statement of defense has been received, it must also be carefully considered to see how matters have crystallized, what has become common cause, and what remains in issue. And at this stage, the adjudicator may again ask for further information if necessary. Some contracts allow for a replication after the statement of defense has been filed. Other contracts do not. And the adjudicator may feel that he or she needs the claimant's response on matters raised in the statement of defense in order to arrive at the proper determination. A hearing may be asked for to receive evidence on specific points or to hear legal argument. If there is a hearing, it must take place within the strict time frames. The parties do not normally have the right to ask for a hearing. This is the adjudicator's prerogative. And a hearing is, the purpose of a hearing is to assist the adjudicator in coming to a decision. I must caution that if the hearing won't serve the purpose of assisting the adjudicator, it mustn't be held, because it can have the effect of delaying the process. And if the adjudicator can dispose of the matter on the papers, I think that is the better course to follow. Now, adjudication has been described as a pay now, argue later mechanism. It is intended to be a speedy procedure for settling disputes on a provisional basis. But that doesn't mean that the adjudicator should approach the task of writing the determination in a cavalier way. Quite the contrary. I think it is a very, very important task, writing the determination, because we should keep the following in mind. The determination is immediately binding and enforceable. If it involves the payment of money, it creates a debt which is immediately payable. It may also impact the contractual relationship between the parties going forward, because it may determine how a clause in a contract should be interpreted or how future calculations should be made. Also, a determination is binding on future adjudications. We very often see that there are a number of adjudications that follow one upon the other in the course of a construction project. But the same point may never be adjudicated again. So keep in mind that your decision is binding on future adjudications. It can make or break a party financially. And if the determination is wrong, it may take long to have it reversed on arbitration or through litigation. By then, the practical effect of the determination may be irreversible. And then delivering a determination out of time could render the whole process invalid. This will obviously lead to wasted time and costs. The parties will have to embark upon the lengthy and costly arbitration process to have the same dispute resolved. The consequences for the adjudicator could be dire. So this underscores the importance, as I've said at the beginning of my talk, to work towards the determination right from the start and all the way through the process, and to make sure that the time limits are complied with and that the award is produced in accordance with the applicable rules. It is advisable to record in your determination how the proceedings unfolded. It should reflect that the proper process was followed. If extensions of time were granted, or the normal procedure was deviated from, this should be mentioned and explained. The reason for this is that if a party should seek to enforce the determination through litigation in court, the determination should speak for itself. It shouldn't be necessary for the party going to court to explain what happened during the course of the process, why the adjudicator gave his award or his determination 2 months after the receipt of the last information. If that happened by agreement and with the consent of the parties, it should be mentioned. Otherwise, question marks hang over the determination. Now, I will turn to my notes, which were distributed, and they're on the screen at the moment. They are intended to provide guidelines for writing a structured determination, and they are not rigid. You must use them and adapt them to suit your own particular style. Not all parts of the proposed structure will be applicable to every determination. Some determinations will require only decisions on facts. Others will only require legal decisions. But mostly, your determination will require a combined decision of law and fact. I noted on the first page of the notes that the guidelines also apply to a large extent to arbitral award writing. Now, let us look at the essential elements of a determination. It makes sense to have a building plan before you commence with the construction of anything. And the same applies to writing a determination. I set out the necessary elements to write a structured adjudication determination. First, there's the heading. Secondly, an introduction. Thirdly, a logically reasoned analysis of fact and evidence. Fourthly, a logically reasoned application of the relevant legal principles. Fifthly, a logically reasoned conclusion in relation to the relief sought, including costs and interest. And finally, we come to the determination in the narrow sense. That is the order which follows at the end of the determination. Now, we will look at these elements individually. The heading of the determination. It may seem silly to discuss a heading in a talk like this, but I think it's important because the determination is a legal document. It represents the determination of a dispute, and the dispute resolution process is authorized by contract between the parties. The determination process represents the conclusion of a legal process, and the determination may up either before an arbitral tribunal or before a court. Therefore, we should follow the structure and the form of headings used for legal documents of this nature. Your determination must be recognizable as a legal document. We refer to the parties in the heading as the claimant and the respondent. Sometimes I refer to them as the contractor and the employer, particularly if the parties themselves have in the papers submitted, referred to themselves as the contractor and the employer. In the tramline of the heading, use the word determination. I think you can also use the word decision, but do not refer to the document as an award or an order or a judgment. Those have different technical meanings. And as far as the citation of the parties is concerned, use their names as stated in the contract between them. So if the contract refers to the parties in terms of their proper registered names, for instance, there may be two companies, use those names. Don't use trading names, don't use abbreviations, use the full proper names as reflected in the contract documents. In the body of your determination, refer to natural persons as he or she, and to corporate entities as it. Then we get to the introduction. This is where the story begins. And it's before you deal with the details of the facts, the contract, the law, and the evidence. Here is where you introduce the parties to your reader, and where you summarize the dispute, and where you tell your reader how the matter came to adjudication and what you are expected to do, what you were expected to determine. Be brief in the introduction. State where, how, and why the dispute arose. If there was a contract, identify the contract, for example, GCC, JBCC, FIDIC, or NEC3. State where and when the contract was concluded, and accurately identify the parties to the contract. Then summarize what the pleadings have to say. Summarize the relief sought by the parties. State in precise terms what your mandate is. In other words, exactly what the parties require of you to determine. This is of extreme importance. You are in a contractual relationship with the parties to perform a very specific function. If you do less or more, you are in breach of your contractual obligations. Your determination may then be invalid and it may be set aside. I think the Fromatome judgment to which Vaughan referred us at the introduction is a case in point. The question there was whether the adjudicator decided the right question, whether they had the necessary jurisdiction to decide the questions as he saw them. Then also in your introduction, without going into detail, state how the evidence in the adjudication was presented to you, for instance, by way of oral evidence, witness statements, or by way of documents, or by way of an agreed stated case. Summarize the essential issues between the parties. You may want to do this under a separate heading if the issues are complex, but normally if it's a simple issue, you can conveniently make this part of the introduction. Now, all adjudication determinations are required to be reasoned documents. And in order to be a reasoned document, it must be a logically reasoned document. You must first have a logically reasoned analysis of the facts and the evidence. This is always the backbone of an adjudication determination. Select those facts relevant to the dispute. They will appear from the pleadings, in other words, from the statement of claim and the statement of defense, and if from further pleadings or even from information that you have required from the parties if you've done so. Now, this is a very important exercise because you must ignore all irrelevant facts. You must search for the relevant facts. Once you've established what facts are relevant, you divide them into the undisputed facts and the disputed facts. Normally, one would do that by comparing the statement of claim with the statement of defense, and you will see where there is common ground between the parties, which facts are not disputed, and you list them and you put them aside. And that's where you commence. You commence with the undisputed facts. You select them, list them, and then leave them alone. Then you go to the more difficult task of selecting the list of relevant disputed facts. Now, my practice is always to put them in chronological order as far as I can do so. It is helpful to state which party contains what In other words, the claimant may say that it validly cancelled the contract, and that the respondent says, no, it wasn't a cancellation, it was a repudiation. When we look at the case study in a few minutes, you will see that that was the major issue in that adjudication, the cancellation or repudiation question. Now, when you record the facts, the disputed and the undisputed facts, do not quote from the documents unless the exact wording is crucially important. Rather, summarize them in your own words. It makes for easier reading, and it also forces you to apply your mind and to understand what is before you. Take, for instance, an issue of cancellation. Normally, the correspondence exchange between the parties would be very important in this regard. Now, sometimes it is very necessary to quote from the correspondence to record exactly what it is one or the other party has said. But for your own sake, digest the documents and rather try and summarize them, because it will help you to also get a good understanding of the issues as they appear from the papers. Now, then we come to a very difficult exercise, and that is where the adjudicator has to decide which disputed facts will be accepted and which will be rejected. You must explain why, and you must apply clearly ascertainable logical reasoning. And this is where the task of writing the determination becomes very difficult. You cannot simply follow your emotions and accept or reject facts as you deem fit, or rely on your own experience and instinctively decide that you will accept these facts and you will reject other facts. This is where you must exercise your judgment in the true sense of the word. And you must do that logically. There are universally accepted techniques to assist us in deciding which facts to accept and which to reject. And those techniques include assessment of the probability or improbability of evidence against the background of all the facts before you. To consider contradictions in the evidence relevant to that issue. To take inherent probabilities into account. And you can also consider a party's failure to present evidence on an issue. Now, I must just at this stage pause to say what makes an adjudicator's task more difficult in this regard than an arbitrator's task is that an arbitrator normally hears evidence. He has the benefit of seeing the witnesses, of listening to the cross-examination, and he can form an assessment and, if necessary, arrive at a credibility finding on what a witness has said. An adjudicator hasn't got that luxury, unless there was, to a very limited extent, perhaps an evidence hearing, but largely an adjudicator will have to make sense of the entire case as it is presented to him. And he will have to use these tools to which I've just referred: assessment of probabilities or improbabilities, considering contradictions, taking inherent probabilities into account, and taking into account the fact that a party hasn't presented evidence on what may be an important issue. Now, the decision to accept or reject evidence on a specific fact is never an exact science. We must always tell ourselves that it is not an adjudicator's function to determine the truth. All you have to do is to establish probability. The test isn't absolute certainty. The test is merely whether a disputed fact has been proved on a balance of probability. Again, here we must remind ourselves that normally the rules of evidence that would apply in a court of law or in arbitrations do not apply in adjudications. But that doesn't mean that the adjudicator can throw out the window normal accepted standards of proof and the normal rules of evidence as they would apply in other proceedings. They are there to guide an adjudicator. An adjudicator must keep them in mind and don't go on a frolic of his or her own because it is inconvenient or difficult to apply the rules of evidence. An adjudicator cannot remain undecided. You must make a probability finding, even if you are uncertain, but you must put the facts in the scales, look at the probabilities, look at the other tools that I've mentioned, and come to a finding. If the scales hang even, you must decide against the party with the onus to prove that particular point. It is as simple as that. It is actually almost a mechanical process, although it can never be an exact science. So this part of your determination should not be neglected, because this is where the readers, the parties, and perhaps subsequently an arbitrator or a court, where they are entitled to know what your reasoning process is. Set it out fully, logically, and step by step. The parties and perhaps a tribunal or a court are entitled to know your reasoning process. As far as evidence is concerned, the law of evidence as applied in adjudication proceedings is a separate subject, which we won't explore today, but I've already earlier remarked that one should keep the principles, the general principles of the law of evidence in mind, because they are very useful guiding tools. Don't discard them unnecessarily. A good knowledge of the law of evidence is essential, as much as a thorough knowledge of the law of contract. And although you can deviate from the strict rules of evidence, you can only do so if you know why you are doing so, and then you must state the reasons in your determination. Two further things must be emphasized. Do not repeat the evidence verbatim in the determination. Summarize the evidence. A summary will force you to understand the evidence, and it will make your determination a reader-friendly document. The method of summarizing evidence applies to oral and documentary evidence. So if there was a hearing with oral evidence, don't quote from the record, summarize it. Don't quote extensively from the documents submitted to you. Quote only where it is really necessary. Otherwise, summarize what the documents tell you. And I get back to logical reasoning. Apply logical reasoning to the evidence. Describe your reasoning process. State your conclusions. Your readers must know, and they're entitled to know, why and how you came to your conclusion. Now we get to the logically reasoned application of the relevant legal principles. This is an important and challenging element of writing an adjudication determination. Disputes may come in many forms. It may be a dispute on common cause facts, which merely requires the application of the contractual terms and the law, or it may be a dispute on common cause facts relating on common cause law relating solely to a decision on the facts. But more so, both the law and the facts will be in issue. Now, applying the law obviously requires knowledge of the law. In most cases in the world that we are living in, namely construction adjudication, it will be the law of contract. And what you do not know about the law of contract, you will have to find in law reports, textbooks, and academic articles. Apply great caution when you do legal research on the internet. I say that because you're an adjudicator in a South African jurisdiction. And unless you've been expressly mandated to apply the law of foreign jurisdictions, apply South African law. Because the principles applicable to the law of contract are not the same in, for instance, the USA as in South Africa. I must just interrupt myself here and say that in my experience, one does find very good guidance from particularly English authorities in adjudication disputes, and the law of contract insofar as construction contracts are concerned. The English law and our law is very similar. There are nuanced differences, but where you don't find guidance in South Africa, I think the next port of call should be English authorities. You can also usefully look at Australian, New Zealand, and Hong Kong authorities. So the ability to identify and find the correct authorities is an important skill. Keep in mind that the law develops all the time. You must remain informed of the latest developments. It is true that you are entitled to make a mistake in law as an adjudicator, but just know that if you apply law from the 1960s to an issue without knowing that the courts have recently pronounced on the same issue, your reputation will be damaged. So finally, clearly display a discernible, logical reasoning when you apply the law to the facts and to the evidence. The next matter that we will look at is the logically reasoned conclusion regarding the relief sought, including costs and interest. Now, by this time, you've stated the facts, you've analyzed the evidence, and you've applied the law to the facts. Now is the time to remind yourself and your reader of what it is that you were asked to determine. Make sure that you are still on the right track. Are you determining the right issues? Are you determining the dispute between the parties? Look at the pleadings. The relief sought appears from the pleadings. For example, the claimant seeks payment in terms of the contract. The respondent relies on incomplete work for its refusal to pay, and it seeks a dismissal of the claim. So remind yourself of the issues. Ensure that your determination is still confined to what the parties required of you to determine. If not, start over. It is easy to become sidetracked. But it is also easy to correct it before it is too late. But once you've signed and published your determination, it will be too late. In this part of your determination, deal with interest and costs if applicable. I'm not going to spend more time on interest and costs. The contract will normally tell you what interest provisions are applicable. And the contract will also tell you to what extent, if at all, you as adjudicator can make a costs award. When you exercise your discretion on costs, make sure that you're motivated and do it in accordance with accepted legal principles. The normal principle is that the result should determine the liability for costs. In other words, the winner should get costs. Lastly, be very careful when you analyze and state the relief sought by the parties. Doing more or less than what your mandate requires from you may render your determination invalid and it may be set aside. Now we get to the determination in the narrow sense. That is the order that you as adjudicator will make at the end of your determination. This requires the utmost care. It must accord with all your findings of fact and law and with your findings on ancillary matters such as interest and costs. And normally, the order part of your determination will have three main components: the primary relief, interest, and costs. Your determination must be specific with regard to who is liable to do what or who must pay whom. State your determination on the merits, in other words, the primary relief, in clear and precise terms. Your obligation is to resolve the dispute, not to create a new dispute on how to interpret your determination. So do not, for instance, simply state that an object has to be returned. Be precise. Say exactly what it is that has to be returned, or if a site has to be vacated, describe the site adequately. If money has to be paid, state the amount clearly and simply. If a declaratory order is issued to the effect that the cancellation of a particular contract is confirmed, define the contract clearly so that your order can be enforced. The successful party may want to and is entitled to have your determination enforced by a court. The court will rely on the formulation of your determination. The order of the court will then be executed by the sheriff. So think ahead. Make sure that your determination is constructed in such a manner that it is clear what is required and that you make sure that it is practically possible to comply with your determination, and that the sheriff will be able to execute your determination. Then, lastly, I noted a few useful writing tools on the last page of my notes. My preference is that one should use short, plain, and simple words. Don't say ordinary and uncomplicated if you can say plain and simple. Use short sentences, one idea, one sentence. Observe the normal rules of English grammar. Avoid the comma, the semicolon, and the bracket as far as possible. The need for any one of these would normally indicate that your sentence is either too long or too complicated. Never number the headings of, if you use headings in your determination. Number paragraphs only and use subparagraphs sparingly. But I think use paragraphs numbers consecutively throughout. So you might write an award of 80 pages. Start with paragraph 1 and end with the final paragraph. Don't mess around with too many sub-paragraphs in between. It makes it easier to refer to a particular passage in your determination if the paragraphs are numbered from 1 to 150 or whatever, and you want to refer to paragraph 139, then you know exactly where to go. Avoid terms of art, foreign languages, and technical expressions. Do not write bona fides, for example. It means good faith. We are writing in English, not in Latin. So use simple language that is easy to understand. Prefer understatement in your determination. Absolutely irrelevant means the same as irrelevant. And you would have noticed that I did not say exactly the same because it means the same as the same. Do not over-explain. A simple footnote reference to authority in point is often sufficient. And if you really need to refer to an example, think very carefully before you use one. And if you think that you need to use more than one example, then it immediately should tell you that your first example was bad. So if you use an example, use one only and make sure that it is a good one. Where you disagree, do it politely. You may be wrong. So do not disagree in strong terms with what a particular party or a party representative has submitted to you. Express your disagreement, but do it politely. Because always keep in mind that you may be wrong. And then finally, don't allow the fear of being wrong cause writer's block. You may go wrong as long as you act honestly and fairly, having applied your mind diligently. Well, having looked at these general notes, I hope that you found them informative and useful. As I have said in the beginning, it's not intended to be a rigid guide. Adapt them for your own use. They are merely tools. Next, I want us to look at the case study which was distributed. Now, I point out that the names, the dates, property description, and amounts in this determination, this case study, are fictitious. The determination, well, you will not be able to recognize the matter at all from reading this determination. Now, I want us to keep in mind the points we discussed earlier when we went through my notes and also my introductory remarks right at the beginning. So when we look at the first page of the case study, you will see that the heading looks like the heading of a legal document. It starts off right at the top where it says in the adjudication proceedings between, and then there's the name of the claimant is stated clearly. You can see it's a company, a private company, and the name of the respondent is stated, also a private company. Between the thrown lines, you'll see that the word determination is used. So just by looking at that, we know now that what we are about to consider is a determination in the adjudication proceedings between Crocodile Construction and Elephant. Now, we get to the introduction. Note that the headings in the determination are not numbered. So introduction is not numbered, and you will also see that all the other headings that follow are not numbered. And you will also note that the paragraph numbers run consecutively from number 1 to the last paragraph. Now, let's see if this introduction complies more or less with the principles that I stated in my notes. The adjudicator says that the dispute between the parties arises out of the construction of a 50-story mixed-use building consisting of residential, retail, conference, and office facilities, together with 8 floors of underground parking, and it's called the Hippo Project on Earth 4, Happy Valley Extension 2, Coltonville. I think that's quite nicely and succinctly put, because once you read that, you know exactly, you can form in your mind's eye a picture of this project, what it is all about. Then he tells us in paragraph 2 that the claimant, and he names the claimant and the respondent. He also names the respondent, concluded a written construction agreement in respect of the Hippo project on 9 July 2014. Then the contract is described in paragraph 2. And the adjudicator says in the last sentence, I will refer to the entire construction agreement as the agreement. So now we know that whenever we come across the agreement elsewhere in this determination, that is what the adjudicator is talking about. He's talking about that document that was concluded on 9 July 2014. Then he goes on to say that on 1 May 2015, the claimant issued a notice of disagreement in terms of clause 40.1 of the general conditions. The disagreement was not resolved, was referred to adjudication. The adjudication is conducted in terms of the JBCC rules for adjudication, the current rules, and the parties agreed to appoint the adjudicator, which appointment he accepted on 5 June 2015. So in one paragraph, you learn that a notice of disagreement was issued, could not be resolved. You know in which clause the notice of disagreement was given. You know which rules apply to the adjudication, and you know how it became about that the adjudicator was appointed. The parties agreed to appoint him. Then he tells us in paragraph 4 that a preliminary meeting was held. He states who the party representatives are, and it is mentioned there that the respondent's representative, Mr. Ntuli, noted that the respondent had additional claims, and the parties agreed that such claims would be dealt with by way of a counterclaim in the adjudication. Then he also states, my appointment as adjudicator for purposes of deciding the counterclaim was confirmed by the parties. Let me just remind you that earlier I stated that an adjudicator must describe how the process unfolded in his determination. Because if there's a deviation from the normal and it is not recorded in your determination, problems may arise down the line when enforcement is sought. So that is why I think it was prudent of this adjudicator to note that there were counterclaims, that the parties agreed that the counterclaims would be dealt with, and that his appointment for purposes of deciding those counterclaims was confirmed. So there you have it. Now the scene is set. You know the adjudicator has been appointed. You know which rules apply. You know the applicable contract. You know that there are counterclaims, and you know that the adjudicator has got jurisdiction to deal with all of this. And all of this was stated in less than 3 pages, because we are now at the top of page 3. Then he states that the parties agreed on a timetable for the exchange of submissions and that they were duly filed. That is sufficient. The adjudicator could have said that it was agreed that the statement of claim would be filed on the 1st of June, the statement of defense on the 20th of June, and this and that. But it's not necessary. He recorded a timetable that was agreed. He also recorded that they were duly filed. That means that the timetable was followed. There's no issue around filing and the exchange of papers. He notes in paragraph 6 that he requested a hearing to receive submissions from counsel. He states the date of the hearing. He says that he was furnished with heads of argument and bundles of authorities, and he notes his indebtedness to counsel for their assistance. That is a courteous way of dealing with it, rather than saying that one counsel made nonsense submissions and the other one was good, or this or that. Stay courteous, stay neutral, just record what happened. Why is the date of the hearing important? It's because you will see that the adjudication determination is dated And if you look at the rules, then you can see that the determination was given within time after the date of the hearing. Then the adjudicator proceeds to deal with the claims and the counterclaims in the matter. I'm not going to read extensively these, what he quoted here from the pleadings, and I note that the adjudicator quoted the relief sought. I did tell you earlier that it's better to summarize. I still think it is better to summarize, but sometimes in complex cases, it is better to quote. And I think this is such a case, because you will see what this adjudicator had to deal with here. There was a previous adjudication determination, which was binding on the parties and on this adjudicator. And in part, the dispute before this adjudicator arose from the determination issued by the previous adjudicator, Mr. Henning. Now, this is what the claimant, and by the way, the claimant in this case, as you will see if you read through the whole determination, the claimant was the contractor, the respondent who had counterclaims was the employer. So the claimant asked for this, declaring that the respondent was not entitled to terminate the construction agreement between the parties because, one, the respondent has been found by Henning SC in his decision of 8 February 2015 to have breached the general conditions regarding the appointment of Zebra CC as selected subcontractor. This breach is a material breach. The respondent has not rectified the direct consequences of the breach. The decision of Henning is binding unless set aside. Clause 36.6 of the general conditions precludes the respondents from terminating the agreement when it is in material breach of the general conditions. Now we know that the JBCC contract provides that if a party is itself in material breach, then it cannot terminate. Then it also sought some supplementary relief, as you will see from paragraph 7.2, which is quoted at the bottom of page 4, and it carries on page 5. Now, here the claimant says that the principal agent failed to properly calculate penalties reflected on certain certificates, that the respondent was not entitled to seek to recover the penalties, and that the respondent is responsible for the principal agent's breach, and therefore the respondent is precluded from terminating the contract. Now, we have a picture in our mind of what it is that the claimant is seeking. The adjudicator then proceeds to quote the relief sought by the respondent. Firstly, the respondent sought a declarator that the claimant was not entitled to suspend the execution of the contract as it purported to do. It seeks a second declarator that the defendant duly notified the claimant to rectify its breach. It seeks a declarator that the claimant failed to remedy the breach. It seeks a declarator that the contract was validly cancelled by the defendant. The defendant, in this case, the respondent or the employer. Firstly, that the claimant has no right to remain in possession of the works and the site, and that the claimant must vacate the site. Now we get to paragraph 9. What does the adjudicator do here? He says, for the sake of clarity, all references in this decision to the claimant are references to Crocodile Construction, and references to the respondent are references to Elephant, then in brackets, referred to as the defendant in the statement of defense and counterclaim. Because it did sound a bit confusing when all of a sudden, when I was reading from the relief sought by the respondent, that the word defendant was used. So for this purpose, and to make quite sure, and in the interest of clarity, the adjudicator stated again who the claimant is, who the respondent is, and that where you read the defendant, it means elephant, in other words, the respondent. But then you will notice from here on that the adjudicator throughout and consistently refers to the claimant and the respondent, because he has now made very clear who the claimant is and who the respondent is. Then the adjudicator noted in paragraph 10 of the determination that in its reply, the claimant had a further request for relief. And what did the respondent seek? It sought an order that the respondent in cancelling the, what did the claimant seek? That the respondent in cancelling the agreement is precluded from alternatively relying on common law repudiation as a basis for cancellation. You will see that if you go through the entire determination, that the respondent, the employer, sought an order that it had validly cancelled the agreement. And for the cancellation, it relied in the main on the terms of the JBCC Principal Building Agreement, but also in the alternative on a repudiation in terms of the common law, which was accepted. Now, this is what the claimant was asking in the replication. It was asking for an order that the respondent was not entitled to rely on a common law repudiation. Then he notes that the respondent also filed a rejoinder, and it said in the rejoinder that the claimant had raised new matter in reply, which was impermissible. So it proceeded to deal with the matter in the event of it being allowed, but the adjudicator records that Mr. Ntuli, the respondent's representative, did not at the hearing persist with the objection, and the adjudicator says, I will therefore proceed to deal with all the disputes placed before me. Let us just remind ourselves, the parties agreed that the adjudicator would have jurisdiction to deal with all the disputes. Now, at this stage, what do we know? We know how the dispute, which is subject to adjudication, arose. We know the relief sought by the parties. We know the applicable adjudication rules. We know the applicable contract. And now the adjudicator proceeds to deal with the factual background, because the contract, the adjudication rules, and the disputes between the parties that need determination, now all of that must be applied to the facts. He deals with the history of the matter, and he states in paragraph 12 that in 2012, the respondent, the employer, negotiated with another party, Kudu CC, to erect this building. Those negotiations did not come to fruition, and the respondent eventually concluded the agreement with the claimant on 9 July 2014, which is now the contract in issue. The adjudicator states then, and this is actually quite important because this gave rise to the adjudication proceedings before Mr. Hennen, which I've already alluded to. He states in paragraph 13, it was necessary to appoint a specialist subcontractor for the installation of glass facades to the building. While the negotiations between the respondent and Kudu were going on, tenders were received from 3 entities. A tender evaluation report in respect of the 3 entities was prepared by Fernando Quantity Surveyors, and the penultimate paragraph of the report reads, we therefore recommend that Elephant Pty Limited, Elephant is the employer, the respondent, consider appointing Zebra CC. So Zebra was recommended as the entity to install the glass facades. But now, just keep in mind that this recommendation was made much earlier. It was made during the kudu stage. Then he says, after conclusion of the agreement on 9 July 2014, fresh tenders in respect of the glass facades had to be obtained. Tenders were received from Tiger Pty Limited and Zebra. So Zebra was the same entity as the one that had been recommended by Fernando. On 31 August 2014, the principal agent issued a written instruction to the claimant to appoint Zebra as the selected subcontractor for the glass facades. The subcontract was signed, and then he records that at a later stage, the claimant terminated the subcontract. The adjudicator records that after termination of the subcontract, the claimant discovered a failure by the principal agent to comply with the provisions of clause 21.11 concerning the process required to be followed by the principal agent prior to instructing the claimant to appoint Zebra. The claimant said that the respondent had breached the contract, and that led to the adjudication before Henning SC, and Henning published his decision on 25 December 2014. Henning concluded as follows: thus, I hereby declare that the principal agent breached its obligations in terms of the GCC. That's not the GCC contract. This is just the general conditions of contract. In this case, read for GCC Principal Building Agreement as amended, in that it failed to furnish the claimant with a copy of the tender received by it from Tiger upon receipt by it thereof, and that the respondent is responsible and bears the liability for the direct consequences of such breach, if any. So this is Henning's determination. And it's important to check and see exactly what it is that he determined and what he did not determine. He did not determine that it was a material breach. And he did not determine that there were direct consequences. He qualified that by saying, if any. Now, the employer, the respondent, was dissatisfied with Henning's decision, and the matter was referred to arbitration, but those arbitration proceedings were still pending. So the adjudicator in this case then states in the last sentence of paragraph 19, the decision stands and is also binding on me in the present proceedings. Now he goes on and deals with the history of the matter. It's not necessary to go through everything that he has stated there. I think I invite you to read the passages that the adjudicator quoted. Maybe you will feel that it was unnecessary to quote the passages, or maybe you will feel that the quotation served the useful purpose to set out exactly what happened. Then, after that exchange of correspondence in which the claimant, the contractor, accused the employer, the respondent, of being in breach, what happened was that the claimant suspended the works, which, according to the respondent, the employer, it was not entitled to do. It was invited to uplift the suspension, but it would not do so. And then ultimately, as is recorded in paragraph 26, on 16 February 2015, the respondent cancelled the agreement. Now, the claimant then disputed the termination of the agreement, and the adjudicator says, I will revert to the cancellation and the grounds relied upon. Now we get to another very important part of the determination. This is where the adjudicator summarizes the disputes. And look at what he says in paragraph 27. He says, there are several issues in the matter. It is important to approach them in the correct sequence. I propose to deal with the issues as follows. So what does the adjudicator do? He reminds the reader that there are many issues, that they must be approached in the correct sequence, and then he gives his proposed sequence. Firstly, was the breach by the principal agent of the general conditions by failing to furnish the Tiger tender material. You'll recall that just a few moments ago, I pointed out that Henning did not find that breach. He found that that was a breach, the failure to furnish the Tiger tender, but he did not find that it was material. So this adjudicator now had to determine whether it was a material breach. Then he goes on, he says, if so, what are the direct consequences of such breach, if any? Because Henning didn't find that there were consequences, you'll remember that he qualified his finding by saying, if any. Thirdly, was the respondent entitled to levy penalties for delay? Fourthly, were the penalties calculated correctly? Fifthly, was the claimant entitled to suspend the works? Sixthly, was the respondent entitled to cancel the agreement? And then lastly, if so, is the respondent entitled to rely on contractual bases and common law repudiation? So again, I ask you to, when you have time, to perhaps read this determination again and decide for yourself whether the adjudicator approached the issues correctly and in the correct sequence. I think this was done correctly. I think this was the correct sequence. But let's see how the thing then unfolds. Firstly, now it deals with the materiality or otherwise of the breach found by Henning. You'll recall that that was the first issue identified by the adjudicator. Then he states the legal principles of pertaining to breach of contract. Then he starts to reason in paragraph 30. And he sets out the claimant's case. The claimant says that it would not have entered into the subcontractor with Zebra had it not been for the breach committed by the principal agent. He gives the claimant's arguments, lists them all there, and then he states in paragraph 31, the onus of proving that a breach is material is on the party asserting it, in this case the claimant. Then he says the test for materiality is subjective with reference to the innocent party. The question is not whether the claimant would have objected to Zebra or whether it would have refused to enter into the subcontract with Zebra. The real question is whether in the mind of the claimant, the breach goes to the root of the agreement. Then he says that is obviously not the case. The claimant prefers to keep the agreement alive. It never considered to cancel the agreement as a result of the material breach. So this is an important finding, because remember that the claimant, albeit that it suspended the works relying upon the breach, which by the way it was not entitled to do, never intimated that it intended to cancel the agreement. So from its subjective perspective, it can never be said that the breach was a material one, because if it had been a material breach, the claimant would have cancelled the agreement. Maybe the adjudicator's reasoning is wrong, but he explains his reasoning and it seems logical. Then the adjudicator deals with the Tiger tender. See, the claimant's case was that it should have been given the Tiger tender before getting the instruction to conclude the contract with Kudu. But the adjudicator considers the Tiger tender and he finds that the respondent's failure to provide the Tiger tender was not material. Then he deals with the next question. So the breach was not material, but he still has to determine whether the breach had any consequences. I'm not going to go through all this detail, but he refers to the Moon report, which was put up as expert evidence by the claimant. The Moon report assessed the failure to provide the tender. Now the adjudicator states what is required insofar as expert evidence is concerned in paragraph 36. And then he finds in paragraph 37, it has been held that to evaluate expert evidence, it's necessary to determine whether or not the opinions are founded on facts and logical reasoning. An expert is required to assist the tribunal, not the party for whom he or she testifies. Then he lists all his difficulties with the Moon report. And he reasons quite extensively around the report. And then he says in paragraph 39, the Moon report does not isolate delays caused by the claimant. It simply lumps all delays together and blames it on the breach by the principal agent. And he says in paragraph 40, for the above reasons, I attach little value, if any, to the Moon report. Then he says, I do not find it necessary to consider the impact of the Mars report, which was put up by the respondent to counter the Moon report. Well, it seems to be a logical and a reasonable approach. If you are ignoring the one report, then you don't have to deal even with the report that was put up to counter the bad report. But then he proceeds to say that he has a more fundamental problem with the Moon report. The author of the report simply makes the assumption that the delays were attributable to the breach found by Mr. Hennon, but no explanation is provided. And the adjudicator says, to my mind, the only possible direct consequence of the failure to provide the Tiger tender was the conclusion of the subcontract between the claimant and Zebra. And he says, where there may be a factual connection, I do not think that the claimant proved legal causation in relation to the delays. Had it been in possession of the Tiger report, the claimant might have objected to the instruction to conclude the subcontractor with Zebra. It might even have refused, but then what? The other tenderers who participated during the Kudu stage did not submit tenders. So the adjudicator explained his reasoning fully in coming to the conclusion that there were no consequences flowing from the breach found by Mr. Hennon. Then he deals, the next question that he deals with is whether the penalties levied were properly levied, and he notes that the principal agent's breach was not material, that there was no causal connection between the breach and the delays. Then he says, I may be wrong. I will therefore consider the effect of clause 36.6 of the general conditions. And he then does so. And he refers to legal authorities, the Group 5 case, the judgment by Judge Nienaber, which was relied upon by the claimant. Then in paragraph 49, the adjudicator says Group 5 does not support the claimant. And he gives his reasons as to why he says that he does not support the claimant. He refers to the argument presented for the respondent in paragraph 50. He again, in 51, refers to the claimant's arguments. And eventually, he, in paragraph 55, says that the subcontract with Zebra was terminated on 22 November 2014, that a period of 20 working days after that date would have expired on 19 December 2014. By then, the claimant's right to claim in terms of clause 29.4.3 of the general conditions had lapsed, and he therefore concludes that he did not have to consider the effect of clause 29.5 of the general conditions. Now, I went through this section of the award quite quickly, but read it for yourself. You will see that, again, there was reasoning, and I think logical reasoning, to arrive at this conclusion. The following question was whether the penalties were calculated correctly. He states in paragraph 56 that the respondent was entitled to levy penalties, and that the question now was whether they had been calculated correctly. He sets out the contentions of the parties. He deals with the contractual provisions in paragraph 58, and he states the contract sum in paragraph 59, and he concludes then in paragraph 60, I do not agree with the claimant. As I've mentioned, the contract value remains equal to the contract sum until the contract value is adjusted. All the payment certificates were issued in accordance herewith. The claimant apparently accepted the earlier certificates, and he concludes in paragraph 62, it is clear to me that the penalties were calculated in accordance with the terms of the agreement. They were calculated correctly, and that the penalty cap was reached. Then he gets to the question whether the claimant was entitled to suspend the works. Now, the claimant's entitlement to suspend the works is an important question, because had it been entitled to suspend the works, then the employer, the respondent, would not have been able to, or would not have been entitled to issue a breach notice and to cancel. Now, he notes in paragraph 63, the claimant suspended the work on the ground that the parties have reciprocal obligations. It contended that the respondent was not complying with its obligations by unlawfully imposing penalties whilst it was in breach. The adjudicator says, I've already found that the respondent was not in material breach and that it was entitled to levy penalties. He notes that suspension of the works may happen only in very limited circumstances. And he says in paragraph 66, in other cases, the contractor had remedies available to it, including the termination of the contract. Then he refers to a New Zealand authority. Now, I did mention earlier that one should always try to refer to South African authorities, but this case seems to me to have been in point, because the adjudicator says that in that case, the engineer representing the employer, for engineer Reed principal agent, was in breach in that he refused to issue a payment certificate. The contractor elected not to cancel the contract, but he did suspend the work, and the question was whether he was entitled to do so. Then the passage from the judgment shows that if the contractor chooses not to rescind, then his obligations continue and he's not allowed to suspend the work. So similarly, in the present case, the claimant chose not to cancel the contract. It was therefore obliged to perform its obligations, and it could not suspend the work. Then, having found that the contractor, the claimant, could not suspend the work, the next question was the respondent entitled to cancel the agreement? He quotes the notice of cancellation, and that the respondent was placed on terms. Then he finds in the last sentence of paragraph 70, it follows that the respondent was entitled to cancel on the contractual basis. But he proceeds in paragraph 71 to deal with the right to rely upon common law repudiation. He analyzes the different arguments, and he then goes on to consider whether the claimant repudiated the contract. He states the test in paragraph 74 and 76. He says that the suspension notice by the claimant clearly demonstrated an intention to be no longer bound by the terms of the contract. And for that reason, he finds, as he stated in paragraph 77 and 78 and thereafter, that there was a common law repudiation and that the respondent was entitled to accept the repudiation and to cancel. Then there's the finding in paragraph 81 that the respondent was entitled to rely upon a common law repudiation. Now let us look closely at the award in the determination in the narrow sense, the order made by the adjudicator. He says, he first of all deals with the claimant's request for relief, and he dismisses all of that. That is contained in paragraph 82.1. And he identifies exactly what he dismissed, so there can be no doubt that the relief sought in all the various forms by the claimant, that has been dismissed. Then he gets to the relief sought by the respondent, and he says it is granted. First, he says the claimant was not entitled to suspend the execution of the works in terms of the agreement concluded between the parties on 9 July 2014. So he identifies the agreement by date. There can't be any doubt. We know who the parties are, and we know that they concluded that agreement. So, and then again, I think out of caution, he defines the agreement as the agreement in inverted commas, and he then continues to use the agreement in the rest of his order. He finds that the respondent duly notified the claimant to rectify the breach, that the claimant failed to remedy the breach, that the agreement was validly cancelled, that the claimant has no right to be in possession of the works and the site. And then we come to the effective order in paragraph 82.2.6. The claimant is directed to vacate the site of the Hippo project on Earth 4 Happy Valley extension to Carltonville forthwith. So if the respondent had to go to court to enforce this determination, the court could issue a clear order in accordance with this determination, and the sheriff could be given a warrant to go and evict the claimant from this properly described site on Earth 4. One thing that is lacking from this determination is a discussion of costs, because you will notice that in paragraph 83, the adjudicator directed the claimant to pay the costs of the adjudicator. Now, this actually required a simple and a brief discussion in the body of the determination. It would have been better if the adjudicator had a short, simple paragraph in which it was stated that in an adjudication in terms of the JVCC rules, an adjudicator has got a limited discretion as to costs. That discretion only pertains to the adjudicator's own fees and disbursements, and he could have given a one-liner as a reason as to why the claimant is directed to pay the costs, quite simply because the normal rule is that the successful party should get the costs, and in this case, the respondent was the successful party. So we've reached the end of this case study, and we have some time left, about half an hour until 11 o'clock, because I was told that my my talk would, including the questions and answer session, should take from 9 to 11. So I see in the chat box that there are some chats. The first question is from Nicholas Briet. Can we possibly get a copy of these notes and the case study? Nicholas, I'm sure that these will be distributed to you. I, in fact, believe that they were distributed to the attendees in advance, but there's no difficulty. They will be distributed to anyone who needs them. Oh, I see that this arose because not everybody got the notes and the case study. There's a question from John Henry Pelser. Do the counterclaims form part of the original dispute? Why not have a dispute on original and then another dispute for the counterclaims? As I understand this adjudication determination, these counterclaims did not form part of the original dispute. The original dispute was raised by the contractor, namely the claimant, and that is why the adjudicator noted that at the preliminary meeting, the respondent, the employer's representative, noted that they also have claims, and then the parties agreed that they be dealt with as counterclaims in the adjudication, and that is why the adjudicator noted that the parties agreed that he would have the jurisdiction to deal with these claims. Had that not happened, John Henry, then certainly the disputes raised by the employer would have had to be dealt with in separate adjudication proceedings. But it seems to me that in this case, it made sense. The parties were sensible to agree to have all the disputes adjudicated upon in the same proceedings. Oh, Uwe says, interesting that the proceedings carried during the annual builders holiday period. Yes, well, I think Uwe take into account that this is a fictitious determination. Michelle Rivarola, your question reads, what remedies does a party have when the adjudicator has not provided a decision or has provided a decision only on some but not all the matters in dispute? The order for specific performance seems unsuitable. Can the unresolved matters be referred to a different adjudicator or only to arbitration, and can the costs paid to the adjudicator be recovered? Well, the remedies that a party has where the adjudicator has not provided a decision or has provided a deficient decision in the sense that he or she did not deal with all the matters in dispute is to issue a notice of dissatisfaction and to go to arbitration, unfortunately. Unless there can be an agreement can be reached between the parties that the matter by consent between the parties be referred afresh to another adjudicator. But unfortunately, if that cannot happen, they will have to live with the consequences of the adjudicator who has not provided the decision or has given a deficient decision. Well, it seems to me that I have dealt with all the questions in the chat box. Are there any other questions that anyone would like to raise? Boitumelo, are you aware of any questions that I haven't dealt with?
No, it seems like you've tackled all the questions that are in the chat box. There's nothing separate from them.
All right, thank you very much. Well, in that case, I thank everybody for attending and for listening to me, hopefully patiently. And I wish you all a happy Saturday and the rest of the weekend. Thank you.